You note it down. Note it down. Ah,
I beg to mention item number 19.
19.
Yes, Lordship. Here the appellant has changed the council, Lordship. So new council will be applied their Wakalat Nama. So our name may be strike out, Lordship.
You send a notice to the right on the prayer of Mr. B. Taivodia, London Council. Item 19. Madam, item 19. On the prayer of Mr. B. Taivodia, London Council for the appellant. List this matter after 4 weeks.
Lordship.
Lordship, may I mention, my lord,
16,
subject to
17,
my lord,
15, 16. Why?
my lord, to fair make submission, my lord, I may be allowed to take some more instruction because I haven't contract with the client.
Sure.
Yes, my lord.
You
And
have, this matter was listed, were listed
Yes,
on
ma'am.
your mention only.
yes, my lord. And my lord, since if my lord, fairly, my lord, if amount is to be deposited, my lord, how that other things has to be followed, my lord, that has to be settled, my lord. And quite
I
apart
said,
from
we'll allow your prayer, but then you have to deposit.
my lord, that is the only my lord, my lord, hardest part, the depositing the amount, my lord, since the trial is not yet commenced. So had it been the my lord, the only that to that extent, my lord, since bond has already been given, everything has been given, my lord, to that extent,
6 weeks.
my lord, that will be again, my lord, the hard, my lord. So
6
therefore,
weeks.
my lord, may I pray that, my lord, I may be given some opportunity, last opportunity to, my lord, accommodate that part, my lord.
Therefore, 6 weeks. We'll adjourn it for 6 weeks.
My
We'll
lord.
adjourn it for 6 weeks.
My lord.
Hmm? Should
Subject
I
to,
record that?
my lord, subject to convenience on the part of the other party.
In fact, reluctantly, we allowed this matter to
True,
be
man.
listed.
I'm sorry, man. I'm sorry.
And Mr. M. Kato, 15, 16, 17, huh? Learned Council for the respondent in criminal petition 326 2016 and criminal revision petition 3 2016 and petitioner in criminal petition 65 of 18 2018 press for further press for accommodation today so as to enable him to obtain instruction. Mr. K. Lolen, Learned Counsel for the petitioner in criminal petition and criminal revision 33, 2016, and respondent in criminal petition 65. There's no objection, Mr.
Lordship, in fact, I have objection, but because of this dependency, trial
okay.
could not be proceeded. Can it be on 30 or 29 or 30? It will be sufficient time to obtain instruction for the petitioner.
Has no in objection for fixing the matter. Has no objection if the matter is fixed within 2 weeks. Having considered the submissions, let this matter be listed after
2 weeks.
4 weeks.
Then may I humbly,
4 weeks or 6 weeks? 4 weeks.
in that case, may I humbly pray that Lordship, the scanned copy of LCR may be sent, may be kept here, and the original may be sent back to the trial court, because since charge sheet was filed in 2018, but because of the pendency,
Registry to retain the scan copy, retain the trial court record. And registry to scan the trial court record and retain it. But scan the trial court record and to retain the same before retain the same. Please retain the same and send back the original trial court record.
They play plus. And my lord, may I mention item number, my lord, 13,
13.
my lord. Here,
Yes.
I'm for the respondents. My lord, only affidavit to be filed, my lord. So
Okay.
4 weeks time may be granted, my lord. We'll file
On the
affidavit.
prayer of Mr. M. Thakur, learned DAJ,
My lord, here the IGP.
DAJ. List this matter after 3 weeks
My lord,
for filing affidavit.
my lord. Deep level.
My lordship, lordship, I beg to mention item number 4. Your lordship, recently I have received a copy of counter affidavit. So 4 weeks time may be given.
Item
Four.
4.
Item 4
Okay.
for
On the prayer of Mr.
J.
J.
Karbak.
Karbak, learned counsel for the petitioner. List this matter. For J. Karbak for the learned counsel for the petitioner. List this matter. After
4
three-
weeks.
4 weeks.
In the meantime, I will file a rejoinder affidavit.
In the meantime, learned counsel for the petitioner may file affidavit in reply.
Yes. Much obliged.
May I please, Your Lordship?
Yes.
I may be allowed to mention item number 2 and 3, Your Lordship.
Ah,
Item number 2 and 3,
2 and 3.
yes. The
Will
conducting,
dispose of the matter.
conducting counsel is out of station, Your
What's
Lordship.
there? Nothing.
It may be heard on her presence only, yes.
We'll allow the writ petition. We'll allow your criminal petition. Give the file. We'll allow the petition. Give the file. You read it and argue. Go through and argue. Yes,
May I, my lord, may I mention item 1,
yes.
conducting the council,
We'll allow this.
my lord, council is out of station. We have already taken the consent from the other side also.
What's there? We'll direct them to dispose of your representation. That's all.
My lord, kindly it may be,
Give him the file. Take the second file. We'll dispose it of it.
I would like to mention item number 7, my lord.
7.
Yes, I am
What is that?
waiting for the petitioner, my lord. I would like to take express step on respondent number 2, my lord.
List this better before any other appropriate match. Without me.
Lordship, may,
Not before this court, huh?
Lordship, I am mentioning item number 8
Yes.
on behalf of AKC. This matter may be adjourned for today. This since this service report of respondent will be police, everything I have told them. So interim order may be
The-
taken.
Ever service report. eh? You be there. We'll see. It's in
And,
listed for orders. We'll see.
Yes. And one more mention, item number 18. That will-
18.
Yes, I have taken the consent of the other party also. This may be adjourned and fixed it after 3 weeks.
3 weeks. On the prayer of Mr. T. Tapak, learned counsel for the appellant. List this matter after 4 weeks. We'll see. Let it come in. Yes. We'll dispose it of. What is your prayer?
my lord, kindly let my senior counsel be present before himself, by himself before this honorable court. It's my humble request, my lord.
Your prayer is to dispose of your representation. We'll direct them to dispose of your representation. That's all. What's there? Heard Mr.
M. Khambo,
Come on, learned
appearing
counsel for
on
the
behalf of Mr. R. Sonar.
petitioners. By, and Mr. S. Tafit, learned counsel for the learned senior government advocate for the state, and you,
On behalf of N. Pada. For
Mr. So and so, for respondent number two.
I'm for one.
And then by filing this application, the petitioner have sought for a direction, have prayed for a direction to the respondent authorities to consider and dispose of the representation of the petitioner in terms of the recommendation of the high power committee
My lord,
for granting employment opportunities to the educated member of the Sulung tribe is notified
my lord,
By- dated 23/12/1998 and 09/11/2011. And the judgments and orders dated 13/11/2022 and 13/7/2015 of this court passed in writ petition 656 of 2001 and PL number PL 19 of 2013. Mr.
my lord, with
Having-
with due respect, my lord, kindly,
Have we considered the nature of prayer? Nature of the prayer made in this, nature of prayer made in this writ petition. The same is taken up for disposal at the admission stage. List of next para. Brief facts giving rise to the present case, come on, are that pursuant to the judgment and order dated or order of the Honorable Supreme Court dated 13/05/1994. In the case of so and so, what is the case, name of that case? 1994? Just give the name of that case. In the case of so and so, reported in 1994. 5 SCC, within bracket, 5 SCC, 116. The state of Arunachal Pradesh has constituted a high power committee to look into the upliftment, rehabilitation and settlement of the bonded laborers and to provide employment opportunity. Mr. The Haifa committee identified the petitioner community as the bundle labor in the district of West Kameng, Kurungkume, Papumpare, and East Kameng, of Arunachal Pradesh. the High Power Committee submitted its report which was communicated by letter 23/12/1998 to the government. Among others, it had recommended for providing government job to the educated members of the petitioner community. Next para. It is the contents of the petitioner. The when the state government did not take any action on the recommendation, come on. The matter was brought before this court by a writ petition as well as the public interest litigation. This court, where is that order of the writ petition? Page 49. This court. On 13/12/2002. In the writ petition, Bofai Purohit versus State of Arunachal Pradesh, reported in 2003, 2 GLR 137. As dispose of has directed, which is reproduced here and below. Huh? There is page 49. Huh? Relevant para is para 11 and 12. Huh? Then where is the PI? Page 54. You are not ready. Next para. In the PL number 19 of 2013, the division bench of this court that the case is Union of Civil Liberties. Was Supreme Court, huh? That case, in the case of Union of Civil Liberties by the state of Tamil Nadu and others. Huh? 1995 HCC 116. Eh? as directed, which is reproduction. Page 54, starting from page 54, huh? But relevant is paragraph 3, 4, and 5, huh? No. Paragraph. Sorry. Paragraph 8. Huh? No, forget it. Paragraph 9. You reproduce the paragraph 9. Page 63. Huh? The basic prayer of the petitioner. The basic grievance, the primary grievance of the petitioners is that despite the directions of this court and the recommendation, despite recommendation and the direction of this court, the respondent authorities are yet to fully redress the grievances of the petitioner community. Therefore, it is straight that the representation filed by the petitioners be directed representations filed by the petitioners be considered, may be directed to be considered and disposed of. Having considered the submissions of the learned counsel with parties and the nature of prayer made in this writ petition, and also as well as the order of the Honorable Supreme Court as well as this court in the above cases, I deem it appropriate to direct the respondent authorities to consider and dispose of the representation. Which representation? Chief Secretary. Yes, Chief Secretary. Latest.
That is 13.7.
13.7.
13.7 is page 75.
70. Not OSD to Honorable Chief Minister. Chief Secretary. 17.6. 2022. Filed by one city. Kabit Bechan. No, not filed. A representation filed by the members of the petitioner community. List of accordingly. It is the present writ petition is disposed of with a direction to the respondent authorities, particularly respondent authority, particularly the Chief Secretary, Government of Arunachal Pradesh, to dispose of the representation so and so, dated so and so. in terms of recommendation list of within a period of 2 months from the date of receipt of certified copy of this order. The writ petition stands disposal in terms of the above orders, above direction. Yes, madam.
Your Honor, in this criminal petition, we are challenging the impugned order dated 15/3/2023 and 1/6/2023, passed by the DC Pasigat under section 133 of CRPC, Your Honor.
Yes.
Your Honor, in this impugned order was passed without following the requirement of section 133 CRPC, which mandates that before passing final order, condition order is required to be passed by giving show cause notice to the affected parties. You know, the boundary wall has been demolished and the building of the petitioner has also been apparent.
Yes.
Your Honor, on the strength of the said impugned order, Your Honor.
Hmm.
So here our prayer is that they have not followed the requisite conditions under section 138 of CRPC, Your Honor. So it may be stayed, Your Honor.
Yes.
Yes, Your Lordship, I don't have any objection because there has been a procedural lapse. However, Your Lordship, if Your Lordship is allowing this petition, since there was a
Direct them to follow the.
follow the
accordance
procedure.
with law.
Yes,
HUD MS
D. Riba.
learned concept for the petitioner in both the petitions. Same order.
Yes,
Same orders.
yes, same order, just,
Same day.
yes, Your Honor.
Same day. Same orders
Yes, Your Honor.
in both the petition.
I have not read the,
You read this second. Same.
same, Your Lordship. Same order, same orders.
This is just
Lordship.
Same.
Same orders.
Okay. HUD MSD learned counsel for the petitioners. Item, this is
2 and 3.
2 and 3, huh? And also MSD learned counsel for learned additional people for the state. Next paragraph. By filing this petition under section 482 of the CRPC, the petitioner have assailed the order dated 15/03/2023 and 01/06/2023 passed by the district magistrate, Asian district, Pasigat, whereby in exercise of power conferred under section 133 of CRPC, the district magistrate has prohibited all types of construction in the construction on the land allotted to the Department of Civil Defense Training Institute at Govindagar, Pasigat, and directed to remove any structure erected on the said land. List of You are in occupation.
Yes,
You are in occupation.
yes, Your Honor.
Next paragraph. Sworn, H-H-O-R-A. And sworn of unnecessary details. Come on. The reflects of the petitioner's case are that they are in possession of the plot of land at Govindagar, Pasighat. By cultivating maize and vegetables measuring about 500 square meters. Mr. Have you applied for allotment? No, nothing is there.
Your lordship, only no objection certificate. He has applied for allotment, your lordship.
Applied for.
Yes.
The petitioners have applied for allotment of their respective occupied land. Mr. Harbour. No, not however. No, however, same has not been considered agenda. Next para. The learned, the district magistrate, by order, which is the order?
Order is at page number 16, your lordship.
16.
16 and 17.
By the impugn orders dated 15 1503 2023. Under section 133 CRPC. Has prohibited all types of construction and to remove evict any structure erected only plot of land allotted for Department of Civil Defense Training Institute at Govindagar, Pasighat, having been found that some unknown person has illegally encroached the said land. Next paragraph. Thereafter, by impugn order dated, another impugn order dated 01/06/2023. The district magistrate has directed the magistrates to perform magistrate duty for eviction of the illegal structure on the allotted on the from the for eviction of illegal structure from the said plot of land. Mr. It is submitted by the learned counsel for the petitioners. That the district magistrate, learned district magistrate has failed to comply with the provisions of section 133 and section 138 of Criminal Procedure Code 1973 and as the as the above provisions mandates that the district magistrate shall take evidence in the matter as in a summons case and shall give equal opportunity to both the parties to make their submission. Mr. If the magistrate is not so satisfied, no further proceedings shall be taken in the case. Mr. Therefore, the provisions cast an obligation on the magistrate to take evidence as in the summons case. Next paragraph. MS so say record hanema dire bashalan. So that submits that whenever section 133 of CRPC is invoked, it is mandatory that the authority exercises judicial discretion by keeping in mind the circumstances of the parties involved. But in the present case, the learned district magistrate has failed to take into account that the petitioners have been residing in the said land for more than 2 decades. Therefore, the orders, the impugn orders have been passed in violation of the provisions as required to be followed under the Criminal Procedure Code. As such, same may be set aside in court. Next para, MS. He's in additional PP for the state. Fairly submits that on their perusal of the orders, it appears that the learned district magistrate has not followed the provisions under as mandated under as mandates under section 133 of CRPC. Next paragraph. I've considered the submissions of the learned counsel for the parties. And where is the documents annexed in the any records? No records. Annexed in the request. Next paragraph. on perusal of the impugn orders. The learned magistrate has issued the orders. No, no, it is on perusal of the impugn orders, huh? Come on. It is noticed that the learned magistrate appears to have issued the impugn orders on an anonymous report that some unknown person has illegally encroached the allotted plot for Department of Civil Defense Training Institute at Gomindnagar, Pasig. And having satisfaction that the such illegal encroachment of the government land and construction are disturbing the public order and tranquility. Come on. The learned magistrate has prohibited all types of construction and to remove or evict any structure erected in the said area. Please stop. Thereafter, the magistrate was deputed for eviction of the said illegal structure from the allotted plot of Department of Civil Defense Training Institute. Next one. The orders have been issued in under Section 133 of CRPC. However, the learned magistrate, having passed the impugn orders under Section 133 CRPC, has failed to follow the mandate provided in the above provision. Mr. Section 133 and Section 138 of the so-and-so, Section 133 provides as follows, huh? You just quote that 133 here. The next Section 138, it's 138, right?
Yes, yes.
Provides as follows, huh? You just quote that. Next one. Having considered the submissions and of the non-constituted parties and also on perusal of the materials available in the, or available on record. I'm of the considered view that the learned magistrate, district magistrate has failed to has failed to follow the provisions mandated under section so and so, huh? 133 and 138 of CRPC. Having considered that the learned magistrate has failed to follow the law as mandated under so and so, the while passing the while invoking the so and so, huh? Impugn order, well, passing the impugn orders under section 133 of CRPC. The impugn orders are deserve to be interfered with accordingly. The impugn orders so and so, huh? Two impugn orders, huh? Are set aside and quashed. Explain. However, the learned district magistrate is at liberty to pass liberty to take actions in terms of the by following the provisions of 133 CRPC. Liberty to take action against any encroachers in accordance with the law.
Deeply.
Much obliged.
Criminal petitions are disposed of, allowed and disposed of. Dismissed.
May I please, my
Fight it out. Dismissed.
lord, after hearing me, my lord.
What
Maybe-
hearing?
My lord, this is a case of very serious nature because the applicants were found apparently on the face of the record that they made false statement on affidavit before the court of law. That is the thing,
You file it out.
my
You
lord.
fight it out there. If it's a false statement,
No,
false affidavit, you fight it out there.
I have given objection, but that's why we are before this
That would
court.
be the part of the, I mean, matter of trial.
No, my lord,
You file an appropriate application.
it is the,
If it is a false affidavit. If it is a false affidavit, you file an appropriate application.
we have filed objection, my lord.
You fight it out there.
No, we fight it out, but kindly see the finding. If the finding of the trial court is totally perverse,
Nothing
my lord,
doing.
at least hear me out, my lord.
I
There is
have
a,
heard you, I have seen your petition. What more you will
my lord, if the impugn order is found to be perverse, this is not the judicious application of exercise of discretion. The law is very clear, my lord. Law is very clear,
Equally very clear.
my lord.
Substantial justice.
Substantial
Not a
justice,
technical consideration.
it is, can perjury or attempt to contempt of
That
court.
is a better to be tried. It's a matter of trial, a perjury or whatever,
My lord,
by the appropriate court.
yes, but the appropriate court,
Until the time it is proved that it's in the perjury. Right?
how it will be
cannot
proved?
just,
My lord,
discard.
I'm just putting a question to myself, my lord. How it will be proved if the finding of the court is totally perverse and the court has overlooked?
What purpose?
Kindly see, my
Until
lord.
it's an allegation. It's an allegation. Has the perjury been established?
Yes, my lord.
Where?
Kindly,
How it is?
it is their own
established?
letter. It is their own letter.
How it is established?
My lord, kindly see.
Has it been established?
My lord, it is their
It's
own,
an allegation and.
it is not
confirmation.
allegation, my lord. It is
What?
not allegation. Their own
Who
letter.
has proved it?
My lord, their
Before
own
which-
letter.
Which court?
My lord, whether
It
these,
has to be proved.
my lord, first it has to be considered. Our objection has to be considered, whether there is any finding to that effect before
That's
the,
the reason I have, this court has refused your,
no, it requires
Inferior.
interference. At least it requires a proper hearing, my lord.
what
Because
perjury?
this,
You show us what the perjury,
yes, ma'am. Allow me, my lord. Allow me, my lord.
but we cannot establish in this proceeding.
No, my job,
First, you have to establish the perjury. And then we'll, if it is established perjury before the appropriate court,
yes, my lord.
then
We-
only will interpret.
We have given documentary evidence, their letter, which defies them, their letter. The records of the customary court, which defies them. Their first plea was that they late receipt of the impugned judgment. That was their first plea.
Hmm?
Their first plea for condonation of delay, the ground is that they received the copy of the impugned judgment belatedly.
Yes.
On 16/5. But kindly see page 54.
Now, how this is established? That is your allegation.
No allegation. It is their letter.
Has the perjury been established?
My lord, how can I establish the perjury if my
Your
objection?
is an allegation.
Yes, there is no denial on their part. Let them deny. There is no denial on their part.
Have you filed an objection?
No,
Not yet.
no.
Fine.
Kindly see the previous order.
So and so, learned counsel for the petitioner. Mr. Judge in learned counsel for the respondent. 6 for further 2 weeks time to file response.
My lord, kindly see the
That this
previous
matter
order.
be the prayer is allowed.
My lord, since,
The respondent is permitted to file response within 2 weeks. List this matter.
my lord, since there is no stay,
After
my
2
lord,
weeks.
kindly, my lord,
After
kindly,
2
my lord.
weeks.
There is no stay. Stay has been
If you
denied to us.
insist, I'm clear.
At least for 1
This
week.
court is clear that we will.
For 1 week, my lord, if possible. Let it be fixed on 21st of August,
Obliged, lord.
4th of August, 4th of September.
4th of September. Obliged, my lord.
Unnecessary. why-
No, my lord, perjury cannot be pardoned, my lord.
How can? How can?
I will place it. Let the matter go for hearing.
Try to
I will
understand,
satisfy the.
try to understand.
Yes, my lord.
Lordship has rightly pointed out, Lordship, in regards to perjury, there should be a complaint. There is a separate
No, no.
procedure for perjury.
That is-
I don't, that's what I'm
Lordship.
saying. I
Let
don't
them
have-
file-
I
let
don't-
them
I
deny.
don't have
They
to-
have not
I don't
initiated
have
that.
to
I will,
tell-
I will satisfy this court, my lord.
It has
if
to,
is
when
required.
you are relying on the perjury, you are not alleging perjury in the proceedings before this court. You are alleging a perjury
My lord, I will satisfy this court. I will definitely satisfy.
before the
this court.
proceedings in the trial court. Not before this. You are
No.
alleging. On the basis of your allegation, this petition has been filed, right? Had
My
it-
lord, my
Had
lord.
there been an allegation, perjury in the proceedings of the court,
I will
this is
satisfy.
something different.
I will definitely satisfy, my lord.
I'll not be satisfied.
I will try, my lord.
Obliged.
Obliged, my lord.
Malad, the standing council, Malad, is in court one.
Hmm?
Standing council.
What is the matter?
Malad, this is a covered matter,
Same,
Malad.
same order. Well, same. What
Yes.
is the work?
Malad, he is
Who is the respondent?
Jitarak.
Your Lordship, I'm on behalf of Jitarak,
Huh?
Standing Council of RWD, Your Lordship. And Your Lordship, we have not received the instruction from the department.
What is that admission?
Malad, kindly see, this is 2024 even,
Where?
page 32, Malad. Meager amount, Malad, this is last amount, Malad.
30?
32, Malad. This is their own document. 15,80,275.
Hmm.
Last column.
What is the admission certificate?
Malad,
Any certificate?
Malad, this is their certificate.
How do you?
You kindly see, Malad, down below PIU means project implemented unit, Malad. This is executive engineer, above is assistant engineer, Malad. The junior engineer, Malad. This is the Malad, authorization letter which they have sent for releasing of the bill amount from the chief engineer. 2013 Malad, work was executed. Now it's almost is more than 21 years.
Call him. Call him. We'll dispose of.
Yeah.
After some. Yes,
Your Honor. And for the petitioner and the service report is not yet completed.
ever service report, list after 4 weeks. What is to be done?
My lord, on the last occasion, an additional PP was directed to produce the case diary, updated case diary.
You have the,
We have the case that.
this for admission hearing.
Yes.
Heard so and so, learned concept of it. And also MS. TG learned additional PP for this state. Scan copy of the trial court record is received.
Your Lordship, a CD,
Please.
it has not been
and
charged
then-
yet.
Scan copy.
Updated copy of the CD.
Updated copy of the CDs. No, the CD is received.
Yes, Your Lordship.
Yes, there is receipt. List for admission hearing after a week.
Deeply. approved.
Ten. Huh? 10.
Your Lordship, item number 10, लेके आए.
Item 10. Huh?
Yes, Your Lordship.
Yes. Yes.
I think it's on.
My lord, I'm
Yes.
appearing. Yes, my lord, I'm appearing in item 11, my lord.
Yes.
Yes, my lord, that's an application, my lord, in under Rule 93 of the Election Conduct
Okay.
Rule for summoning and production of documents from the electoral offices, my lord. So your lordship will see para 1. This is a petition, my lord, where your lordship has already issued notice to the respondent. This is today only is the application is listed for summoning of the records. So now, my lord, in paragraph number 8, which is at page 11, I have narrated the documents, my lord. Basically, these are, my lord, marked copy of the electoral rolls, postal ballot papers, videography, register of voters. I have given the relevant provision of the rules also, as well as the handbook of the election conduct. So, my lord, my humble prayer is that, my lord, the concerned authority may be directed for production of this records before this honorable court.
It's okay. We'll fix on the, when is the next date fixed?
But that is on 22nd, my lord.
We'll take it above. We'll just issue a notice to the respondent.
Very well. But
Whatever.
yes, my lord. But these are, my lord, papers.
Yeah, it's okay. We'll consider. We'll pass an appropriate order on that day. We'll just
All
issue
right.
a notice.
All right.
Fixing
well.
the same on 22nd. All right.
On
Heard
22nd.
Mr. So and so, learned counsel for the petitioner. Applicant. Next para. By filing this application under section
Under Rule 93.
under Rule 93 of the Conduct of Election Rules 1961. The applicant has prayed for production of the documents from the custody of the production of documents from the custody of the district election officer Kurumkume. District election officer public returning officer of Kurumkume, public returning officer of 19 Nyapin within bracket ST Assembly Constituency of the following documents. What I said for production of documents, so and so, no? Which are as follows. You
Page
just,
7, Milord.
Page 7. Huh? A, B, C, D. Huh? E. Up to?
Page 11, Milord.
So many. Page 11. Up to 11. Huh? Issue notice to the respondent. Returnable by 22nd.
22nd of this month. Yes.
22nd. The applicant to take steps for service of notice upon the response. You take steps.
Yes, Milord. But one thing I would just wanted to point out, Milord, because the respondent is only the returned candidate, because the officials election authority is not a respondent in this petition, Milord. So therefore, because if your lordship see the original petition, because as per the rules, we only have to annex, we only have to array the returned candidate, not the officials.
No, it's okay. You take steps.
Very well, we'll do that.
For notice. Huh?
Very well, we'll do that. Grateful.
During the course of the day.
Very
Take
well.
steps today.
Very well, we'll do that. Grateful.
Yes.
This revision petition is against this discharge of the coefficient.
Huh?
Discharge of the coefficient.
Why IA?
Interlocutory application for condonation of delay in filing this revision petition. Notice will be required.
Revision. What is the prescribed period for revision?
90 days, Your Lordship.
And Mr. So and so learned counsel for the petition applicant. Next paragraph. This is the application under section 5 of the what? Read. It's criminal procedure code.
Yes.
What? Yes. You read your what's title?
This is under for
Limitation.
Limitation under CRPC.
limitation under Indian.
Read it. You are so casual.
But under Indian Limitation Act.
Evidence Act.
Indian Limitation.
Evidence Act.
Not even Indian Limitation Act.
Then, sir, you cannot allow it to be so casual. List after list list on Monday.
We will make a
The
correction.
parties may file an approved application for amendment of the cost item. You cannot casually allow like this.
Deeply.
My lords, I was appearing in item number 13. I'm appearing in
Yes.
item number 13.
What is
My
to be
lords,
done?
on an earlier occasion, the respondent sought time to file the counter.
When the service was, when the steps were taken? Heard Mr. So and so, learned counsel. for- 13 already adjourned. Are you appearing for which item? You are appearing
Item
for which
13.
item?
Item 13,
13
my lord.
already adjourned.
Already adjourned, my lord. Okay.
For
I was
filing
not
affidavit.
informed beforehand, my lords.
Okay, you just item 13 heard Mr.
Ketan Jain. K. Jain.
Ketan Jain so and so, learned counsel for the petition. Then the same order, Mr. M. Kato, na? Learned
Yes, my
DAG, so for so and so, na? Praise for and granted. We have granted some 2 weeks or 3 weeks time. 3 weeks. You had
Obliged, my lord.
your name is there. Huh? Item 14.
Lordship, here I have not received any extra copies, Your Lordship.
Hmm?
I have not received extra copies.
This court has time and again indicated. Don't wait for the extra copies.
Lordship.
It's a matter not to be. It is not or technical thing. Anyway, the non-appears for the petition on call. MS next para. Arbasar London State Council is present. Please talk. What is the matter?
Lordship, matter. His grievance is that respondent authorities, he wants the respondent authorities to stop the payment to the respondent number 4. He's the attorney holder for contract work, Your Lordship.
How they read lines on that? That's
Yes,
why
actually
that's why I'm asking.
the grievance is against the private respondent number
That's what
4
I
only.
mean. That's why
Yes.
that's why I'm purposefully asking you. Without information, without instruction, you can submit this. It's a matter of law only.
Yes. Lordship.
Anyway, it's in the order stage. How the notice also, right?
Notice has been issued, Your Lordship.
Why did not you raise an objection?
I didn't appear, Your Lordship.
Oh, you means the government lawyer?
Yes.
These are the matters you should raise an objection at the motion stage.
Yes.
Notice is also not deserved to be issued. Anyway. Office note dated 14/08/2024 reflects that service report in respect of Sulung is still awaited. List the matter after 4 weeks. Next paragraph. The maintainability of the present writ petition shall be considered on the next date.
Okay.
Yes. Item 6. Huh? All right, here. Yes.
He's in the coming month.
It's the same.
Yes, same.
Only the
Amount is,
amount and work is different.
yes.
So it is similar order. It is you just write the work will be
Work is, my lord,
Where it is, I tell you, it's in pending system. For construction of,
yes,
road from 700 kilometer point of Pakke dash Lada road to Tara, which is
Tara.
prepared stage one under package number 7 with an estimated cost of rupees 254.36 lakhs. Is it same?
yes,
Same order?
yes.
You just page, what is
Because of the inquiry, my lord, this was stopped.
that? Huh?
Because of the
Same,
inquiry, yes.
same.
Yes, same.
Only difference there. Page 50, my order, and then, should be different, and then bill of so and so, you find it out. You change the book, same order. Where I allowed this
Yeah,
all the,
cover
you
case.
pay within a
Within 3
within a
months.
month.
Money is there already since 2000.
No, if it is there, then with, it may be for 3 months. Otherwise, it has to send to the
It's all right.
Delhi.
We have already waited for 21 years, mother. 3 months is nothing. 3 more.
2000 कितना का है?
13.
There's something like, hey, they wrong, it has not disputed the.
13 on इसका है.
This is right. Page 50. Amount, and, thing. The work will be different. Yes, it's okay. Within a period of
3
3 months,
yes.
with interest.
No. There is no provision. No oblige.
This called it. Over.